what are my fears for Ghanaian democracy as a result of the entry of no-prosecution withdrawal cases. First of all, I look at everything from the perspective of public accountability. It's very important that there's accountability for all officers who hold offices which are deemed to be public trust. So if you occupy a public office, you're supposed to be a trustee of public power and authority. And therefore, once you have no difficulty at all accounting for one's stewardship. And so when persons are prosecuted for specific financial crimes and all, it assumes a greater importance because indeed it borders on the use of the public purse, which they are supposed to be trustees of and what have you. Therefore, as far as I'm concerned, there ought to be a determination of the merit of the offense that the person has been charged with. And it becomes therefore worrying when, after courts of law have established that it's a case for a public officer to answer in respect of a specific financial offense that they have been charged with, an attorney general exercises discretion, evaluates evidence in his chambers, calls on counsel for the defense, and say that indeed that accused person ought not to open his defense and that the case is closed. It becomes more worrying when indeed the effect of that is to confer what we call in law an acquittal, which is akin to a determination of no wrongdoing by the accused person. But that's a judgment that ordinarily ought to be passed by a court of law. So my view is that once an accused person has been adjudged, that's the case for the accused person to answer. There's no basis at all for an attorney general to sit in his office or his chambers to scrutinize the evidence and speak to counsel for the defense and say that the accused person ought not to answer. And even impliedly confer an acquittal on that accused person. It's unconscionable. And I would think that there's actually sufficient basis for a questioning of the provision in the Criminal Offences and Other Offences Procedure Act 30, which effectively confers on the Attorney General the power to pass a verdict on a crime that has been that a person has been charged with. But effectively, if that's the case, then it means all an attorney general should do, especially, I had been a holder of the office, I can cite myself. So various allegations have been made against certain ministers, maybe without any basis at all. I just can collude with Minister A and say, Minister A, let's quickly file a case against you in the courts of Ghana. Once the case has been filed, we call a few witnesses, close our defense, and then close our case, call upon the accused person to open his defense. Once it starts, then I enter a withdrawal, and the person would have been acquitted. And there cannot be a reopening of that case. Because once the person has been acquitted, it ends the matter. I think it provides basis for sufficient abuse, especially in all these cases. You saw there's a case that had been made, the court held that Signal Punin was the case for him to answer, Signal Punin and two others. They went all the way up to Supreme Court. They did not succeed. Same happened in Thompson. Some counts, the court said indeed there was a case for him to answer, as well as Ofusampo. Ofusampo, for the same day that Atufosi was acquitted by the Court of Appeal, the same panel actually held that Ofusampo had the case to answer. And subsequently, the attorney general comes less than a year and says the person has no case to answer. So that's my view. It provides basis for abuse, and indeed you must look at it from the point of public accountability. An attorney general, by the exercise of such powers, and effectively shield members of the public from public accountability.